As restaurant HR leaders and operators, managing wage garnishments isn't just another payroll task. It's a legal responsibility. And in an industry that's filled with tipped wages, with multiple deductions and high turnover, even small payroll missteps can create major compliance risks. Non-compliance can lead to costly fines, it can lead to lawsuits, and even in some cases, personal liability for the owners or the managers. So today I want to break down 10 important things that you need to know to stay on track and avoid garnishment-related problems in your restaurants. Garnishments are based on total earnings, including reported tips, not just the low hourly wage. This is critical in our restaurants where tip income makes up the bulk of pay. Under the Consumer Credit Protection Act, or CCPA, wage garnishment is capped at 25% of an employee's disposable earnings. That's income after legally required deductions or the amount by which weekly earnings exceed 30 times the federal minimum wage, whichever is less. For child support, the cap is higher. It's up to 50 to 65% depending on dependents and back payments owed. Not all garnishments are treated equally. Child support, federal tax levies, and bankruptcies, those orders take precedence over other debts like creditor garnishments. When an employee has more than one garnishment, you need to follow both federal and state laws to determine the proper withholding order. It's not always straightforward, especially with all of these conflicting rules. Failing to withhold and remit garnishment wages properly can result in you, the employer, being liable for the full amount owed, plus penalties and legal fees. Before I share the rest of the tips, quick sidebar here. At Restaurant HR Group, we don't just help restaurants navigate wage garnishments. We handle payroll, HR, compliance, and a whole lot more. Whether you need full support or help getting things sorted out, we have got your back. Visit us over at restauranthrgroup.com to learn how we can simplify your people operations in your restaurants and help your leaders become the best versions of themselves. Some states provide more protection to employees than federal law. When that happens, you must follow the law that favors the employee. Many states allow employers to charge a small fee for processing garnishments. Just gotta make sure that you check your state's rules because some states don't allow it. If the IRS issues a wage levy, the exempt amount the employee can keep is based on their filing status and number of dependents. Use IRS publication 1494 to determine how much to withhold. If wages have already been deposited via direct deposit, creditors might go after the employee's bank account, and at that point the money is no longer considered wages and different rules apply. If an employee files for bankruptcy, most garnishments must stop immediately, except for child support and some tax obligations. Wage garnishments can be overwhelming, but they don't have to be. When you understand the rules and you stay proactive, you protect your business and support your team with confidence. If you are looking for a partner to simplify payroll, to handle garnishments correctly, and take HR off your plate, we are definitely here for you. Let Restaurant HR Group be your go-to people partner. On demand, ongoing, and always on point.